Matter of Rosalyn Musker versus Suuchi, if I'm pronouncing that correctly. May we please have appearances of counsel?
Bruce L. Atkins, George Atkins, and Owen Belford.
Deputy Attorney General Daniel Musker here for the Department of Labor.
Alan Shore here for the National Employment Lawyers Association.
Morning, Richard Rhoda, Pyro, Zinnes, Sofelli, Paris, and Jenna Temple for the defendants.
Good morning, counsel, and welcome. Mr. Atkins, please go ahead.
Thank you, Your Honor. Justices of the Supreme Court, I want to thank the court for taking this serious matter under consideration. The subject of this argument is whether commissions that are paid on a tiered basis or in addition to salary are protected under the wage payment law. I believe the argument is clearly yes, because it is the tiered commissions are benefits of the person putting out the labor to create the owing. So therefore, whether it's tiered or not, it is not discretionary upon the sale for the benefit of the employer. Commissions plus salary, many employers have a base salary plus commission. That shouldn't change the nature of the commission, which is paid to an employee for the benefit of their labor. They make a sale of product, the employer benefits. The employer clearly benefits, and if there is a commission schedule, the commission should be paid to the employer. I mean, to the employee. I apologize, I have a cold, so please apologize. Earned commission, and I cite to page 3 of the sales commission compensation agreement that was signed in this matter. Earned commission is compensation earned by team members based on rates described within this agreement. Well, it's commission, it's wages. In addition, the salary that a particular team member gets is also mentioned in the sales compensation plan. So both the salary plus the commission structure is mentioned. In addition, the commission structure provides for amendments for different products. That is in fact what they did when the pandemic commenced. They added PPE. This is a company that did $6.8 million gross in 2019. My client sold $32.8 million in PPE in the 4 months following the March 2020 pandemic. It was not a one-time deal, and no one knew how long it would last. It was sell what you can, make money for the company, and you'll make money. And that's exactly what the owner of the company said in an email. This is a matter of statutory interpretation of the wage payment law. Most particularly, the amendment in 2019 was an amendment to prevent wage theft. This is and was the ultimate wage theft. They never paid her more than $100,000 for $32.8 million. She should have received on the low end of the scale, 400 and something thousand, and on the high end of the scale, $1.3 million, because there was still a question of whether it was net or gross, based upon the email exchanges from the CFO and the owner. There is nothing about this other than it's tied to the production of the salesperson. So therefore, when you make a sale of X product, you get a commission of Y. That's wages. It can't be anything else. Supplementary incentive, it's only if it's discretionary, a supplementary incentive. This was not discretionary. If you make the sale, you get paid. And again, I emphasize the Earned commission is compensation earned by team members based on the rates described within this agreement. What else could it be? Whether payment is calculated independently of regular wages, if it's not calculated independently, it is a wage. It calculated based on product sold, as stated in the sales compensation plan, earned by team members based on rates described within. How does the statute apply here? Is there anything about what happened here that makes these PPE commissions a supplementary incentive? The answer is no. The fact that Suuchi incentivizes employees to sell PPE makes no difference. All commissions incentivize. All commissions incentivize people to sell product. The more you sell, the more you make. It's tied to the work and labor of the employee, and it's not calculated independently. You make the sale, it's whatever that commission percentage is, you get paid. This is commonplace all over the place. As long as the employee's commissions are directly tied to the labor or services provided by the employee, then such compensation falls within the definition of wages under the WPL. Everything is wages as long as it's calculated based on the sale of the product. Ms. Musker was entitled to commissions because they're a direct payment to her for the amount of product that she sold. They are not supplementary because the amount that Musker would be compensated for each sale of PPE had already been established by Suuchi's sale commission plan, sale compensation plan, I apologize. The payments made to employees for their sales and revenue that those sales brought in were not discretionary, nor independent from the product sold. The commission payments were already known in advance based upon the sale of the product.
So what category of commissions would be outside the scope of the definition of wages?
Stay bonus, for example, a retention,
Commission, I'm sorry.
pardon?
I thought that Justice Patterson had asked what type of commissions would be.
Oh, I
outside.
apologize. Did I mishear that? I apologize.
Thank you, yes.
I think if you have for example, if they had a commission program where if your team sells the most at the end of the year, you get paid a commission additionally. But then that would be the effort of your team, not just you.
So where in the statute do we find this guidance?
Well, it talks about commissions.
Or are you saying that all commissions, I mean, you just said if it's a team bonus, you could make the same argument with respect to a team bonus because everybody's working and the company's benefiting.
The reason I wouldn't make the same argument is because it's not just, if it were me, for example, it would not just be my effort, it would be my effort with other members of my team.
That may be true on commissions that a sales rep working with other sales rep achieves.
But again, separately from what that person would be paid for doing what they do to sell, because
So
that's
it's a
their
team-
labor.
All I'm saying is where's the distinction with team members? Because you could presumably sales reps work together all the time to.
Well, my argument would be if it's not discretionary, then it's commission and it's labor and it's wages.
So if it's not discretionary, meaning what?
Meaning if you do X, you get paid Y.
And what kind of, I'm simply asking you are you arguing that all commissions are wages under the statute? And if so, what's the basis for that? And you're saying there may be this team effort, but I think if the argument covers a sales rep's efforts, which may be very much augmented by somebody else's work, the same would apply.
But yeah, for example, if they had a sales contest,
A sales
like a contest among the salespeople, who sells the most? If someone sells the most,
And they get a gift
they
card?
get a gift card, they get a
It's
bonus.
not a commission.
No, I agree. That's not
So my
commission.
question is, is there a category of commissions under your interpretation of the statute that would not be wages?
Yes, that type of thing.
But you were just saying that's not a commission, not a commission.
That it's not a commission
So if it's
because
a commission, is it wages under the statute according to your interpretation of the statute?
based on the statute, which includes commissions as part of the wages, it would be part of the claim. If it is a,
So the answer is all commissions.
well, I do believe there would be types of situations which would be outside the wage payment law,
So what are they?
but not this one. In this case.
Got that. But what are they? You're asking for the court to interpret the statute.
Well, for example, if you achieve, let's say, an increase of 5% over last year with new customers, we'll give you a $10,000 bonus
Why isn't that a commission?
because it's not directly tied to the labor because you're getting paid for the labor that produces those commissions. This is a bonus on top of that you've reached a certain level.
Based on your labor, based on the work you did.
It is based on the labor, but you're being paid for the labor at that point, and then you're getting a bonus for achieving a certain level.
So what is, I'm just turning to the appellate division's definition, bear with me 1 second. Appellate division viewed supplementary incentives to mean additional compensation or perks that can motivate employees to take actions beneficial to the employer above and beyond monetary payments directly owed to them for their labor or services. What's wrong with that definition?
Because this requires labor and effort to achieve what they in fact did. So for example, here, the sale of PPE. The sale of PPE, they said, hey, we're going to include it in the sales compensation plan. Go sell, go make a lot of money. They never said, oh, by the way, this is supplementary. They amended the sales compensation plan. Therefore, it is inclusive of wages under the definition of the wage payment law.
And then I know what your argument is with respect to your client situation, but obviously the court has to draw a line that would involve other cases as well. So
Right.
what is it that you would have the court state as the principle that would guide future litigants and courts?
If And I appreciate the question, and I think it requires some deep thought in the sense that if a contest or a level is established that if you do X, Y, and Z, we'll pay you a $10,000 bonus, that is outside wages. That's on top of wages. Therefore, you could set up a program whereby if you achieve even in their sales compensation plan, if you got 110% of quota, you got a bonus.
And what is the principle that would distinguish that from your client situation? Because it seems to me that the person is working toward that bonus, putting in extra effort. It helps the employer.
Exactly.
But you're saying that's out.
No, I don't know if it's out or not in this particular circumstance, but I'm saying there could be circumstances based on how it's set up. For instance, in SLUCA, where they set up an end of year, if you do X, you get Y. SLUCA established end of year bonus as opposed to during the year, you do your 2% or whatever it was in SLUCA, you got wages for that.
So are you relying on the part of the definition in NJSA 34:11-4.1C that talks about excluding any form of supplementary incentives and bonuses which are calculated independently of regular wages and paid in addition thereto?
Right.
Are you trying to make the point that if it's paid as part of a salary, if it's paid along with a salary as part of regular payments on a monthly basis or bi-monthly basis, and it's based on how much you sell, then it is a commission that is recognized as part of wages in the WPL. Whereas if it's a one-time, you could get $10,000 at the end of the year in a separate check, then it is calculated independently of regular wages and paid in addition thereto. Is that what
That
you're
is absolutely what I'm suggesting.
And so here specifically in the SCP, it states, quote, commission payments are made on the last monthly regular pay date that corresponds with the Suuchi payroll processing schedule. Commission amounts due are paid on the final payroll of each month for all commissions meeting payment criteria as of the prior month end.
That's correct.
And one of
And
your,
it is not discretionary.
I was going to ask, one of your responses to one of Justice Patterson's questions was that if it is not discretionary payments, then they are wages. So can you explain how you're drawing that line with regard to the discretionary payments and how you are asking us to determine what is discretionary and what is not discretionary if an organization has indicated they're going to make a certain payment at some point?
Many companies say we will pay a bonus at the end of the year in management's consideration. That is not mandated. That is, oh, you did a great job, here's a $10,000 bonus. Or you did a great job, here's a $5,000 bonus. That to me is independent. But if you sell
Independent?
independent of wages
The wages that are
earned,
provided on a regular basis during the year.
exactly. You sell this product, you sell this product, you sell this product, you sell this product, you get a wage. And whether you have a base salary or not, many employees have base salaries plus commissions. And I will suggest that since Musker was published, people have been hurt because they're using it to say, oh, a salary plus commission is supplementary.
So
Not
what
wage.
prevents an employer under that theory or the distinction that you're drawing from simply structuring it so that there is an end of year check for $10,000, not directly based on amount of sales, but the employer's general view of the performance of the employee?
Right.
You're saying that's out of the statute.
The general performance of the employee, if I'm the employer and I had to give a discretionary bonus of $10,000 or whatever to the employee because I'm happy with the job they did, that's fine. But to not pay that
You say
employee,
that's fine. That's out of the statute?
that's discretionary. But to not pay the employee for making the sale of the product for which they delineated what the commissions would be, that is wages, and she should have been paid.
Counselor, if I could call attention to the SCP on page 3. And said that earned commissions is compensation earned by team members based on rates described within this agreement.
Right.
But there certainly are aspects of the rates for the PP that differ from this agreement. And in fact, if you look at page 4, it says, and I will admit a bit of an ambiguous or vague phrase, all commissions are based on ARR. And then it goes on to say, will be paid in 3 equal installments. But these commissions aren't based on ARR, right?
They're not, but in a way they are, because the emails that were sent by the CFO saying they will pay commissions on the sale of PPE pursuant to the SCP, and then another email by the owner of the company saying, we'll treat these the same as ARR. Go sell, make money for yourselves,
So they're
as
not,
well as for the company.
these products are different from the software subscriptions that the company often sold because those subscriptions were subscriptions and the
They
payments
are.
would come in ARR, their annual recurring revenue, as opposed to a one-time individual sales of products.
They are different, but the sales compensation plan also provides for amendments.
Right. Well, what I'm saying is they're these products, the PPE sales would not fall under the ARR because the nature of the sale and the nature of the product is different.
It's certainly different than the nature of the software product that was being sold by the company.
And
So
the
it makes
email
sense that they're not that they're not the same as the ARR. The ARR.
No, but when the company says they're going to treat them the same as ARR.
Right, and there's going to be no
Okay.
penalization for ARR.
Right.
Correct. The company doesn't say this is ARR. They just said, quote, we are providing same commission on these one-time orders and not penalizing for not being ARR, end
Right.
quote. So they're acknowledging it's not ARR. They're just saying we're choosing to pay commission on this as well.
Right.
Yes.
Because they can't be just the nature of the product. It's not, isn't annual recurring revenue for potentially one-time sale of products.
But it ended up being more than one-time sale. And no one knew in March of 2020 that how long this was going to last, how often PPE was going to be sold. To say it was a one-time sale, it's not a one-time sale. It's a product sale. It was a new product added to the menu. And a new product added to the menu for which my client ended up doing a tremendous amount of sales. She doesn't get paid a commission. And that goes to the 2019 amendment and the concept of wage theft. She's been paid a total of $100,000 on $32.8 million worth of sales. She should have been paid if, and again, there's a dispute as to whether it's 4% of net or 4% of gross.
And that's not part of the grant of certification.
And that's not part of this, no. But
Can you clarify something with respect to the fact issue related to that? The company paid you $100,000, not the 1.3 million that you claimed. The 1.3 million would have been based on gross sales. If the commission were based on net, what would the amount have been from your perspective?
about 405, almost 500,000.
Thank you.
Either way.
If the company didn't believe that this was any form of commission, why did they pay $100,000?
Well, that's a good question to ask the employer. I mean, there's no question that my client has been trying to get paid for 5 years. And she hasn't been. It's been a nightmare for her, to say the least.
Is it relevant to us? Was that part of an attempt at a settlement of your claim, the $100,000 payment?
I'm sorry, Judge.
Is it relevant to what we have to do today in that, was it perhaps an effort at resolving the dispute?
No, it's not relevant because it's not resolved.
Well, it was paid before there was any dispute, right? I thought it was paid in April and May of
It was
2020.
paid for the early sales. Then the subsequent sales, that's what's not been paid. So the sales for May and June into July are what's not been paid. So the 100,000 was paid for the sales in March, April. She got paid in May.
That was on top of her annual base salary of 80,000.
No question. And everyone in that company had a base any salesperson had a base salary plus commission. And that's the whole concept here. The theft of wages, as delineated in the 2019 amendment, this should have been liberally construed by the appellate division. It wasn't. It was strictly construed. I thought this was a remedial statute to prevent wage theft. And in fact, to me, this is the ultimate wage theft committed by this employer.
Other questions?
I would wrap up my argument with the following. In my argument, the wage payment law compelled the payment based on sales, which benefit the employer. The 2019 wage theft amendment was to prevent the failure to pay commissions, which is exactly what happened in this case. I ask the court to correct the outrageous wrong that occurred here. Thank you.
Mr. Atkins. Mr. Rosalyn.
Thank you, Your Honors. Good morning, and may it please the court. I'd like to start by following up on the colloquy that we had earlier on about whether all commissions are wages. We think that answer is simply yes. The wage payment law defines wages to be, quote, direct monetary compensation for labor or services rendered. Commissions definitionally meet that basic definition, and therefore all commissions are always wages. True enough that sometimes this language is used loosely. I can't say that no employer has ever called something a commission that ought not be properly considered a commission. So the simple use of the term commission is not what renders it a wage. It's the fact that it is direct monetary compensation for labor or services rendered.
So a commission, so how should we define commission?
A commission is one type of payment that is a direct monetary compensation for labor or services rendered. That's the threshold upon which all kinds of.
I'm sorry, I missed part of that.
It's just directly pulled from the statute, Your Honor.
You're just using the statutory definition.
It's direct monetary compensation for labor or services rendered. That's what defines all wages. The statute goes on to give examples, and it says that that can be calculated on a time, piece, task, or commission basis. But the method of calculation is not what makes it a wage. What makes it a wage is the fact that there's direct monetary compensation for labor or services rendered. So a commission is anything that meets that definition that is calculated as a percentage of a sale.
So what is a supplementary incentive for purposes of the DOL's interpretation of that statutory term?
We agree with the definition laid out by the appellate division. We think a supplementary incentive is anything that is additional compensation that can motivate employees above and beyond the monetary payments directly owed for their labor or services. That comes directly out of the appellate division's decision. We think that's the right definition.
And what would be an example of this, not necessarily from this case, but just in your general experience?
The appellate division lists 3 examples, and I can offer a few more. The 3 listed by the appellate division are payments offered by employees for being willing to share your office, or for being willing to work out of a particular office location, or perhaps an award for perfect attendance. I can offer a few others, but the core defining principle is it's payments that incentivize employees to do something, but that something is not labor or service. It's something. It could be the conditions of your workplace. It could be any other ancillary item, but it's not the work that you're performing. That's what distinguishes supplementary incentives.
So a bonus paid at the end of the year that is paid for excellent performance, where does that fall?
So bonuses and supplementary incentives we think are subtly different. They're the 2 exceptions under the statute. We think supplementary incentives are payments that are not for labor or services. We think bonuses are distinguished on the basis of the fact that they're not owed, that they're not due or promised.
Can you just say it one more time a little bit slower? So supplementary incentives are
payments that are not attributable to the labor or services of the worker.
okay.
A bonus could be attributable to labor or service, or it could be wholly unrelated. That's sort of beside the point. What makes a bonus different is that it remains within the employer's discretion, that it's not due or owed or promised.
So if a bonus, I'm sorry, Chief. Go ahead. The bonus is, there's an announcement of bonuses for certain employees who have done a superb job in selling our products this year. It's amorphous term, no numbers involved. Is that in or out of the statute?
It would depend on whether it was promised in advance. If it's promised in advance, as in the employer guaranteed it, then it very likely would be a wage. I mean, it would depend on certain factual circumstances.
But in reality, once bonuses are given at the end of a calendar year, it's been essentially promised in advance, has it not?
Oh, so sorry. If the payment
expectation, it's not that they say it's 2025, we're going to give a bonus, we're also going to do it in 26, but employees tend to expect repetition of positive things like bonuses. Where does that fall?
True enough, Your Honor, it would depend on the level of expectation. What makes a bonus is whether or not it's due. And dueness is essentially a product of whether something has been promised. But true enough that
someone couldn't sue to say, I got a bonus last year and this year I was expecting a bonus and I never got one. Presumably the employer would say, these are discretionary. We don't promise any bonuses.
Very likely that's
you do well this year.
Very likely that would be the case, Your Honor. True enough that there are some cases where it was ambiguous and the expectation was so great, the repetition was so strong that they viewed it as effectively promised. But still, the question is whether the bonus is due or promised. It's just that in some of these cases where terms are ambiguous, courts have looked to expectations to clarify that.
I'm sorry, could you just repeat the last point you made?
Sure. It's that bonuses are bonuses by virtue of the fact they remain within employer discretion. Some courts we understand, although bonuses are not strictly at issue in this case, so they're not briefed. Some cases we understand look to employee expectations to clarify where a bonus it was unclear whether the employer was or was not promising a bonus. But ultimately, the question of whether it's a bonus or not is whether it was due or owed or promised. That's what defines a bonus.
But the debate as to whether an expectation that developed over a number of years has little to do with whether it is a commission.
Correct. Yeah. The supplementary incentives and bonuses, we think, are discrete categories. They're both exempted under the WPL, but here we're talking about is whether it's a supplementary incentive or a commission, right? So the question of expectations doesn't come in the way that it would if there was a debate about a bonus.
Because you're saying this is a wage, not a bonus, and not a supplementary incentive.
That's correct, Your Honor. Like all true commissions, this commission at issue is a wage.
You're also saying that the commission and the bonus could be tied to the work involved. Is that accurate as well?
Commissions must be tied to the work involved as a wage. Bonuses could be tied to the work involved. It's sort of beside the point on whether it's a sort of a side issue. What defines a bonus is whether it's due or owed or promised.
Where in the statute do we find that? Because I don't see the word discretion anywhere in the statute. Instead, I see which are calculated independently of regular wages and paid in addition thereto. So it seems like if you got an end of the year $10,000 bonus that is calculated independently of wages and paid in addition thereto, it's some sort of separate paycheck. So regardless of whether it's discretionary, that seems like a bonus and not like a wage.
Fair enough, Your Honor, that the statute does not further define the term bonus. The appellate division in their decision outlines that one of the factors that makes a bonus is that it is additional to wages, right? So the core thing under the core statutory term is wages itself, which is direct monetary compensation for labor or services rendered, right? That's what's in. That's the clear category of in. On the outside, you have any number of payments that are either not direct monetary compensation or are not attributable to labor or service. Those are the two bases by which something can become a non-wage, right? We think supplementary incentives are non-wages by virtue of the fact that they fail to meet the second half. They fail to meet the attributable to labor or services part. Bonuses are a slightly more complicated question. There's case law developing exactly what that term means, and it's also not directly at issue in this case, but we think bonuses are the other half of the other side of the coin, which is to say they're not direct monetary compensation by virtue of the fact that they remain within the employer's discretion.
Either way, we wouldn't have to specifically reach an exact definition of bonus here because even the appellate division didn't find that this was a bonus, correct?
Correct.
We need to focus on supplementary incentives.
I think that's right.
And you're comfortable with the definition the appellate division offered. Obviously, the application here, you differ with the appellate division.
I think it's subtly different from that, Your Honor. We definitely agree with the definition, and we do disagree with the application, but we don't disagree with just the application. We disagree with the consideration of factors that go beyond the definition that the appellate division offered. So the appellate division defined supplementary incentives to mean additional compensation that can motivate employees above and beyond monetary payments directly owed to them. But then it considered a number of factors that don't go to that inquiry. It considered the minutia of which product was being sold. It considered the terms by which compensation would be calculated. It considered the presence of an underlying salary. We think none of those things are relevant to the inquiry because the inquiry, as the WPL lays out, is simply whether it's direct monetary compensation for labor or services rendered.
So, I'm sorry, go ahead. Finish.
That was the end of my thought, Your Honor.
Does it matter whether the commission is calculated in addition to the base salary?
I think not, Your Honor, and here's why. The WPL has the definition, and then it lists several methods of calculation by which a wage can be calculated, and it says time, task, piece, or commission basis. A salary is merely a wage calculated on a time basis, but it places them all on equal footing with each other. So it cannot be that the presence of payment on the basis of time somehow renders a payment on the basis of commission that would otherwise be a wage into a non-wage because the statute places them all on equal footing.
So just to understand where the sort of how the exclusionary phrase works, if an employee is operating under a payment structure that says at the end of the year, an employee will receive a bonus of 5 to 15% at the discretion of the employer, does that mean that up to 5% should be considered wages and whatever that bonus is above 5% can be considered a bonus excluded from the wage payment law?
Your Honor, that's a complicated hypothetical because it's not 100% clear what at the discretion of the employer is modifying, whether it's modifying the range or the existence of the bonus. I think that'd be a tough question.
Modifying the range.
Okay, look, assuming the terms explicitly modify the range, then I think there would be a good argument that at least 5% would be a wage because it was promised and due and owed, and it's attributable to the labor or services. It's a trickier case.
Can you come back to the hypothetical that Mr. Atkins was asked? And that is, if the team sells X number of widgets, they will get a payment. How does that fall under the statute?
Your Honor, it would, of course, depend on the specific terms, but we think very likely that that would be payment on the basis of task, right? The task is to make X number of widgets, and upon completion of that task, you were promised payment. That's direct monetary compensation for labor or service.
Change it to sell. If it sells 10,000 widgets, where does that fall into the statute?
I think that the same would be true. It would still be labor on the basis of a task. The task was to sell 10,000 widgets.
You earlier said there may be circumstances where a commission with that label is not actually a commission. Can you give us an example?
It's tough to say, Your Honor, because it would definitionally be a misuse of the term. I struggle to even come up with one. Perhaps someone could say, if you're willing to share an office, I'll give you a $50 commission. It's kind of a nonsense use of the term, but sometimes employers use these terms quite loosely and they don't always follow.
You're saying that how an employer characterizes the payment is not in and of itself the only inquiry, correct?
That's correct, Your Honor.
But here, under the facts of this case, would you consider parts of the SCP, for example, parts that have already been quoted about an earned commission being a form of compensation earned by team members based on rates described within this agreement, or the commission payments being made on the last monthly regular pay date that corresponds with payroll processing schedule? So how much do we consider how the employer set this forth versus how much do we say, the employer doesn't get to determine this just by how they set it forth?
I can't say that the employer's characterization or terminology is wholly irrelevant. It might be relevant for sussing out what the intent of the parties was in the employment relationship. But on the most part, the characterization of the employer is not the relevant inquiry. The relevant inquiry is whether you meet the definition: direct monetary compensation, labor or services rendered. Both are met here, and therefore you have a wage, regardless of whether the employer happens to have called it a commission or not.
Going back to the hypo you were discussing with Chief Justice Radler, if let's say in this case, or in that hypothetical, the employer says, if you're willing to share an office, I'll enhance your commission structure by 0.1%. What would that 0.1% be?
Very interesting hypo, Your Honor. I think that it's an unusual way to pay out a supplementary incentive, but I think that would properly be considered a supplementary incentive because it's not attributable to the labor or service that the person is providing. It's sort of an ancillary issue. It's the conditions of employment, but it's
even though the number that resulted from that calculation would be in part the result of labor.
Well, actually, that's a valid point. So sorry, let me revise my answer. I got a little caught up in the hypothetical. I think because you're still talking about ultimately the compensation being tied to a sale, and that sale is the work that a salesperson has been hired to do, you would still have it be a wage. It's a convoluted wage, but I think it is a wage.
You mentioned sharing an office. You mentioned, I think, coming into the office or something along those lines. Can you give us a few more illustrations of what this is? Because this supplementary incentive language is obviously prominent in the statute. And at least speaking for myself, I'd like to get a better understanding of what the legislature was thinking about.
Sure, Your Honor. I can give a few more examples. I do want to preface by saying that we do think this is quite a narrow category. It's not to say it's not in, the mere fact that it's listed alongside bonus doesn't mean that it's as common as a bonus. It just merely means that the legislature was doing its due diligence in carving out non-wages. So we have things like being willing to share an office, being willing to work out of some particular office, perhaps a perfect attendance award, something like referring a friend to an open position, money for participating in an office costume contest, perhaps, and this is one we've seen, money for being—
I'm not sure that helps the employer to have a costume contest, but—
Well, it might. It helps the company culture. The employer wants it. They've offered some money. They say, if you participate in the costume contest, I'll give you $10. That is a supplementary incentive. It's truly ancillary to the terms of employment. It is not work itself.
What you seem to just say to me is the exact same activity could be treated as a commission or not a commission, depending upon how the pay is structured. That's how I think I understood your revised example to my hypo to be. When you started off saying that's a supplementary incentive, but actually that may be a commission. It seems to me that what we've boiled down to now is the exact payment, exact same payment could either be a commission or not a commission, depending upon how that ends up being structured. If it's structured pursuant to a commission schedule, it would be a commission. If it's structured pursuant to some other schedule, it may not be a commission, it may be supplementary incentive, even though it's the exact same amount of money for the exact same activity.
Your Honor, what distinguished between a commission in your hypo and a non-commission is whether the pay is attributable to the labor or service that a worker performed. So in your example, you said that they would get a little extra payment for sales. So it's the tie to sales that makes it a wage, right? Mere commission is just a mode of calculating payment, like time, task, or piece, right? So the real question is not whether something's a commission or not. Commission is just one mode of calculation. The real question is whether it's a wage or not. And what makes it a wage is if it's tied to the labor or service.
So if there's a salesperson who wants to build the talent of the sales team by finding someone outside the company, and the company says to the team, by the way, if you can find us really qualified salespeople, we'll pay you $10,000. That $10,000 would be, under your definition, of supplementary incentive that had nothing to do with direct monetary compensation for labor or services.
I want to say yes with an asterisk, Your Honor. And the asterisk is this. Certainly recruiting is a form of labor that a recruiter might perform. So the line might be slightly tricky in certain circumstances on whether someone is a recruiter or a recruiter is part of their job responsibilities. We think that the more ordinary circumstance.
You're referring to the average employer knows a friend and brings a friend, and not somebody who's paid to be the
That's correct, Your Honor.
HR person. Or
That's correct.
I'm wondering if your first answer to the hypothetical from Justice Hoffman was the right one and not the revised one that you adopted. And here's why. In the hypothetical, the bonus is being paid a certain way. And the commission payment that you receive, let's assume it's 1% on the sale of the product, but you're going to get an extra 0.1% if you switch offices. Isn't that extra 0.1% a method of calculating what the supplementary incentive is going to be, but not a commission payment?
I'll concede that it's a borderline case, Your Honor, and I'm not 100% sure how it should come out. But here's my suggestion, is that because the compensation is still directly tied to work performed, that's what makes it a wage. So I think what you have there is payments that are in part supplementary in nature, but in part a wage, right? But where that's the case, it must be a wage, right? The general provision must prevail.
Have you ever seen anything along those lines?
Well, this court says that something similar in Prado versus State.
No, I mean the hypothetical.
Oh, no, Your Honor, certainly not. That would be a very unusual circumstance.
Has DOL, I'm assuming not because I don't see them cited, but are there regulations explaining this to employees and employers to give some guidance?
There are regulations, Your Honor. We don't think they really illuminate the question of what is a supplementary incentive in particular. We think for
There are
that,
regulations that expand upon, because I just checked to make sure I was right in my recollection. You didn't cite any in your brief. Should we look to regulations to help us with these definitions?
not on the question presented here, Your Honor. There are regulations more broadly explaining the terms of the WPL, but not this exact part at issue.
Other questions, anyone? Anything you'd like to add, counsel?
Nothing further. Thank you, Your Honor.
Thank you, Mr. Shore.
Morning, Justice. Neil in New Jersey, we represent these people, a group of about 200 employment attorneys who have these issues come up every single day. We review contracts that come up every single day and commission programs. Neil in New Jersey submits that to the answer to the very first question, there is nothing, there's no commission that is not a commission. There is no wage that is not a regular wage. The statute clearly defines wages as direct monetary compensation for labor or services, including commissions. So a commission is a direct payment that is calculated for the sale of products or services. The statute exempts those payments that are calculated independently and paid in addition thereto. And there is a bright line so that a commission can never be a supplementary payment, and a supplementary payment can never be a commission.
Do you agree with counsel for the Attorney General's characterization of what constitutes a supplementary payment?
Not entirely. Okay, one thing that's important is that a discretionary payment, there was a question, well, you couldn't sue an employer for a discretionary payment. I believe you can sue an employer for a discretionary payment. If the employer says, we're going to give you a stay bonus, and if you stay for another 6 months, we'll give you a $25,000 bonus. You can absolutely sue the employer and collect that, but not under the WPL.
Yeah, okay, but I thought the whole context of that was a WPL claim.
Correct. And the fact whether it's discretionary or not discretionary is not relevant. What's relevant is whether the payment is calculated independently of products or sales.
Do you agree with the appellate division's definition? I'm not talking about the application of this case, definition of what constitutes a supplementary incentive.
Yes, they defined it correctly, but in application, they missed the all-important part of the statute that says that a supplementary payment is one that is calculated independently. Because the first part of the statute says if it's direct monetary compensation for labor or services, it is a regular wage. That is regular wages. Then it exempts those payments that are not directly compensation for labor and services as being those payments that are calculated independently and paid in addition thereto. And therefore, the statute is actually very clear. There's a bright defining line, and any hypothetical that we have can be defined simply by saying, are you being paid for what you sold? Or is what you're being paid calculated independently from what you sold? Even in the case of a bonus where the calculation is such that, well, we'll give you an additional 2% at the end of the year if you open more accounts, the payment is paid, but it's not the direct monetary compensation for labor and services.
So the bonus that's just for good performance or outstanding performance.
Good performance, there's discretionary bonuses. Almost every contract that I see now today, executive compensation, we will provide up to a 20% bonus at the end of the year. It's discretionary. It's not tied to parameters. Relocation bonuses. Severance packages, attendance bonuses. These are all calculated independently. Now, here's an example. An employer decides that they want to give an incentive for employees to work the night shift. So they put in a $2 wage differential. Obviously, that is tied to the work. It's an incentive. The employer intends it to incentivize employees to work the night shift, but they are paid an additional $2 an hour and per hour that they work.
That's wages.
As wages.
So that's clearly under the statute.
It's wages, of course.
But you gave us examples of what would be supplementary incentive, relocation, severance. I assume the examples given by the Attorney General about sharing an office, showing up certain places, going to this or that office.
And again, where we differ from the Attorney General is that there was an implication that if it was promised, if it's owed, then it's wages. And I think that that's not a clear definition, because they could owe a stay bonus. They could owe a discretionary bonus. They could owe any kind of a bonus, and you could sue them for it, but it's not covered under the WPL. And I don't believe that the employer's intent to pay or the fact that they're obligated to pay is what brings a payment into the WPL's protection for wage theft. It's whether it's direct monetary compensation for products sold and not something that is calculated independently and paid in addition thereto.
So that might be a breach of contract theory in a lawsuit,
yes,
but
of
it's
course.
not a WPL.
Of course, we do those all the time. But we don't get treble damages and attorney's fees because it's payment that is calculated independently and paid in addition thereto. And therefore, you can sue, you can get your damages, you can't get treble damages, you can't get attorney fees under the Wage Theft Act.
Thank you, counsel.
Thank you.
Mr. Gronick.
Good morning, Mr. Chief Justice, justices of the Supreme Court. As I listened to the argument this morning and the questions from the court, it occurred to me this is a far from perfect statute, as many statutes are imperfect. It's incumbent upon the courts to interpret and, when necessary, upon the legislature to amend or revise. And I submit to you that's what we've got here. And that's what the appellate division suggested when they concluded their opinion. But before we get into some of the hypotheticals, I'd like to speak preliminarily about the specifics of this case. Mr. Atkins described this as the, in his words, ultimate wage theft. I want to talk a little bit about the circumstances. During the course of Mr. Atkins' argument, it was acknowledged that the issue of 4% gross versus 4% net is not part of this motion. This is an interlocutory order under review. The trial court, August of 2023, in granting partial summary judgment, determined that it is 4% of net, which is exactly what my client wanted to pay in May of 2020. And Mr. Atkins is correct. That is $476,250. At least that's what the estimate was, because the net was still being calculated. There is, in the record, page 688 of the plaintiff's appendix, is that email making that presentation. And it was said, and we'll throw in nearly another $50,000 to bring it to an even $525,000. So if this case is remanded and the court determines that the commission structure is subject to the wage payment law, should Ms. Musker be permitted to argue in front of a jury that that $476,000 was stolen from her? There's some very powerful words that are used in the course of some of the briefing. Senator Weinberg was quoted. It was a question about regulations. We have some of the legislative history. Senator Weinberg was quoted, "Wage theft is immoral, intolerable." Senator Greenstein was quoted, "Unscrupulous employers robbing the hardworking people of New Jersey." That's the purpose of the statute. We're looking for legislative intent when we interpret a statute. Could it be the legislature's intent to penalize the employer under these circumstances, where the very figure she would have been paid going on 5 years ago now was rejected? Can she now go before a jury and argue that was stolen? I want 3 times that plus my attorney's fees. That could not be the legislature's intent. And I wanted to make this argument before the appellate division, and Judge Sabatino said, no, that's Rule 408. You can't talk about settlement. Rule 408 is narrow, not narrow, it's broad in its application. It applies when negotiations are intended to prove liability or the amount in dispute, but certainly not under these very, very unique circumstances where that offer, she'll get 4% of net, is the difference between whether or not the statute was violated. So if the court is not prepared to look at those very specific facts and is going to leave that for the trial court in some measure, I strongly ask that some guidance be provided to the trial court, because it's offensive to imagine that a statute designed to remedy such a very serious wrong, theft of wages, should not be applied under the circumstances we are looking at here. I want to talk a little bit more at this point.
Before you leave that point,
Sure.
what is the guidance that you think we should provide? Is that really an evidentiary question?
Well,
Because that's not before us.
well, what I suggest is before you, Justice Patterson, is this very question of legislative intent. Is the legislative intent designed to focus, as the senators who I quoted earlier, instances of wage theft when an employer kept wages rightfully owed to an employee? No different, for example, if one of my associates, today's Monday, our associates get paid. One of my associates gets his check. I'm not cashing this check. You promised me a raise. I'm not going to cash it. He's rejecting, he's not paying his wages.
But that's an issue ultimately, is it not? If the case were to be tried, would be in a question of the admission of evidence of those discussions, no?
I don't think so,
That
Justice
seems to be,
Patterson.
I just don't see it as part of what the court's being asked to do.
I was concerned that that might be the court's reaction. And that's why I suggested some guidance in the course of an opinion, because if the opinion is going to be interpreted by a trial judge.
But we granted certification only on one question,
I know.
and it's the definition of wages in
Right.
the WPL. And the
Right.
WPL defines wages as the direct monetary compensation for labor or services rendered by an employee, where the amount is determined on a time, task, piece, or commission basis, excluding any form of supplementary incentive and bonuses, which are calculated independently of regular wages and paid in addition to thereto. That's the only thing we granted certification on, and that's what we've been discussing. It seems like you're arguing that the legislature should have added a separate affirmative defense, that if the employee refuses to accept the compensation, then they can't bring a suit. All of that has nothing to do with us, correct? So can we focus on the statute and why a commission doesn't fall within it, within the definition of wages, even when it specifically says that a commission does fall within it?
I will, but I do want to comment on another section of the statute, if I may, because there is what I'll call a safe harbor of good faith defense,
Okay.
which arises when a first offense, if you will, where the employer is made aware of the statute and makes good by making the payment.
Did you make the payment?
Sorry?
Did you make the payment of the 500,000?
No, the payment was not made.
I'm sorry, which portion of the statute are you referring to?
I'm referring to a section of the statute. It was, if I may, actually, I think I have it in my notes. I know it, I believe it's in the, I don't have the particular citation, but I believe it's in the Deputy Attorney General's brief, the specific citation to that good faith defense.
So counsel, let's look at the statute itself and,
Yeah.
and try to interpret it. And we begin with the plain language. What is the common meaning of the term commission? How do you define commission? Don't look to the back end of the statute just yet.
Fair enough. I view a commission as being something paid for direct labor. I don't quarrel, very frankly, with some of the definitions that each of my opponents have in different ways presented today. But it's not just what is a commission. To qualify as wages, it is the exception. I'm going to break down those 20 words.
What is the exception? I'm sorry.
I'm talking about with the exception to what are wages, supplemental incentives, bonuses calculated independently and paid apart from regular wages.
So before we get there,
Yeah,
Webster's defines a commission as a fee paid to an agent or employee for transactions of a piece of business or performing a service, especially a percentage of the money received in a sale or other transaction paid to the agent responsible for the business, i.e. a commission of 9% on a sale. Do you quarrel with that
No.
definition?
no,
Should we look beyond that plain language and apply a multi-factor analysis to figure out what a commission is?
I think you have to look beyond that definition in order to make sense of calculated independently and paid beyond regular wages. And I've listened to to the colloquy today about discretionary payments. To my mind, calculated independently means subject to a formula. Calculation implies a mathematical process, which must be pursuant to some objective standard.
Which you have in this case. No?
Yes, we have in this case.
So there's a promise of a payment for
Right.
the sale of PPE
Right.
based on a commission type schedule. No?
My point, Mr. Chief Justice, is this. There was colloquy this morning about discretionary payments, a bonus paid at the end of the year, or if you move into someone else's office or share the office, you'll get 1%. That is not designed to incentivize. To the extent it's discretionary, it isn't subject to calculation independently of what is regular wages. Look, bear with me a
Sorry, it
moment.
sounds like you're saying, if I'm understanding this correctly, that every commission where there's a commission schedule set forth is calculated independently of regular wages and paid in addition thereto. Is that what you're arguing?
Yes and no. I'm sorry, but yes and no. I've got to answer it both ways.
Okay, so what's the yes and what's the no?
The yes is in terms of a regular commission structure, but that's not this case.
Sorry, can you say it one more time? The yes is what?
Let me go to it in this fashion if I can.
Mhm.
She was hired first in management, then she converted to sales. She was selling the subscriptions that was referred to before to the platform, which were multi-year subscriptions giving rise to ARR. This was a one-off that was generated, that was created in the response to the pandemic. And as was pointed out, it was essentially prepared, crafted, if you will, on the fly.
But it says we are providing same commission on these one-time orders and not penalizing for not being ARR.
Right.
So it can't possibly be that it's not a commission because it wasn't ARR. Regardless of the specific facts of this case, I was asking more a general question, which was, are you arguing that all commissions are not wages under the Act, as long as they're paid on a commission schedule? And you said yes and no.
Yeah,
So what's the yes and what's the no?
I'm getting a little confused between the yes or the no. So let me just do this a little bit more directly. If we were dealing with the subscriptions for which she was hired, which was her job, those commissions would be wages.
Even though they're calculated independently of the salary based on some sort of commission schedule.
Right.
Okay.
But what we're dealing with here is a unique set of circumstances, and that's the other side of what I was trying to say before. There was a unique moment in time where this opportunity existed. The sales force was told, work hard, sell, being incentivized, and you will not be penalized because these are one-shot sales. The merchandise was being sold pursuant to single purchase orders. Whether there was a second purchase order at some point in time doesn't change the fact these are one-time deals, which otherwise would have been paid at 1.75%. It's important to understand that. So in this unique set of circumstances, that takes this structure out of what otherwise might be wages. I hope I'm making sense.
Can I come back to the statute with you for a second?
Yeah.
Is a bonus a commission?
No.
Is a supplementary incentive a commission?
Could be.
How so?
Again, we're back to where we started. The supplementary incentive, a noun, derives from a verb, incentivize. So when someone is told in the course of being incentivized, you will receive a payment, that is not a commission that falls within the definition of wages. Again, this is an imperfect statute.
I'm not sure what that means. Can you tell us again
Yeah,
in slightly different words?
I'll try to say it again in entirely different words. Under the circumstances of this case, where this market was being identified for the first time, in an effort to meet the needs was arising, the sales force was told, this is a whole new product. We're going to deal with it differently. Sell as much as you can. You will get paid in accordance with the tiers. It won't be treated as a one-time sale subject to 1.75%. And therefore, it falls within what I consider to be, as I said before, the exception to supplementary incentive calculated independently, subject to the tiers, and paid in addition to what your regular payments would be.
They
So
specifically, sorry.
Take it out of the facts of this case
Right.
and tell us what a supplementary incentive is and how is it different from a commission?
Most instances, it probably is not different from a commission. If this were, again, I think I tried to say before, if we were here because she wasn't paid a commission associated with the sale of a subscription contract, I think that would be part of her. That would be part of her wages. But this is different.
Isn't a supplementary incentive something different from a commission? Otherwise, how does the statute make sense?
It doesn't make sense.
It does if it's a different construct, because what it says is commissions are wages, but we're excluding supplementary incentives. If they're the same thing, then we could read the statute hypothetically to say commissions are wages, excluding commissions. That would make no sense.
I would agree with you. That would make absolutely no sense.
So what is a supplementary incentive?
Supplementary incentive, again, is a payment designed to incentivize performance, calculated pursuant to a formula, and paid outside of the regular payment format.
But that's a commission itself is designed to incentivize performance and it's paid pursuant to a formula.
Right.
And in this case, it was paid with the exact same formula. And they specifically sent an email that said, we are providing same commission on these one-time orders and not penalizing for not being ARR. So I'm just not even sure, A, how to ground your argument in the statute, but B, how it helps you here, where they said, we're paying this pursuant, we are providing same commission. Meaning we're paying this pursuant to our commission schedule, which you said makes it a commission and not a supplementary incentive.
All I can say in response is the payment was designed to motivate, to incentivize.
Aren't all payments designed to do that?
Well, that was a very coherent and cogent argument made by the Deputy Attorney General in support of the Department of Labor's position in the case. But that could not have been the legislative intent, because supplementary incentives are excluded from the definition of wages.
But commissions are not, and commissions are undeniably to incentivize someone to sell something if they're being paid a percentage of the sale, correct?
Right.
So if we focused on incentives, we'd be writing commissions out as well.
I suppose so.
I think what I was hearing, if I understood the arguments of the two amici today, is that the incentivizing that happens in the case of supplementary incentive is not just make this sale and you will get this commission. It is help our business in some other way that is not directly tied numerically to a sale. So the examples were provided were the share an office, go to an office that perhaps would not be your first choice. Do other, mention a costume, $10 to participate in a positive event for the employer and so forth. These are not, this is not, you have a sale and you're going to get 1.5% commission, but this is our office, our business is multifaceted. There are many things that promote the success of our business, and these are non-numerical incentives. What's wrong with that definition?
I'm not sure there's anything wrong with that definition, but when your honor makes the point that these are non-monetary, then it seems to be,
They're not, I wasn't saying they were non-monetary. I was saying that these are all hypotheticals, but
right.
it's been helpful to me to discuss them with counsel. We have too many of X category of offices, and we don't have enough of offices in the location that you, the employee, might prefer. But if you bear with us with our current space limitations and you go to this other office, we're going to give you a bonus, or you're going to give you an incentive for doing that. That's not a percentage of sales. It's not directly tied to the performance of the employee, but it is an incentive that helps the business, in the judgment of the employer, to be successful. And that would be out of the statute, not wages, and considered a supplementary incentive.
By that definition, or that example, there is no independent calculation, again, part of the exception. It is just, you do this for us and we will give you some money. That could not be what the legislature intended.
Sorry, how is that not an independent calculation if they say you'll get $10,000 if you're employee of the year?
It's a random
Isn't that
number.
independent in that it's not paid once a month and it's not paid every other week, however your regular payments are being made? It is independent of that, separate check.
It's a random number, Your Honor. There's no calculation involved. The language of the statute, again, speaking of calculation independently, implies a mathematical formula. That's what a calculation is.
But then how would any bonus, if anyone, in many companies, they'll say, you'll get a discretionary bonus at the end of the year, and we decided this year it's $100,000, just because that's what we decided. Are you saying that is a wage and not a bonus?
Oh, not at all.
Because it's not calculated independently?
Not at all.
Not calculated?
Not at all. That's a bonus. There is supplementary incentives and bonuses. They are two separate methods of paying money to an employee.
Correct, but the statute, the statute doesn't attach the word calculated to supplementary incentives. It actually comes right after bonuses. So the statute says, excluding any form of supplementary incentives and bonuses, which are calculated independently of regular wages and paid in addition thereto. You seem to be saying the word calculated does all the work and there has to be some sort of method of calculation. But why would that apply not to the word bonuses and only to the word supplementary incentives, when bonuses is the word that comes next to calculated?
I read the statute this way, Your Honor, that phrase, calculated independently, applies to both incentives and bonuses, which
so you get a $100,000 bonus because you were a good employee.
Yep.
I thought you were
Not a
saying that
wage.
then it can't be calculated because calculation means there has to be some sort of scientific method, I thought is what you were saying.
Again, for supplementary incentives, calculated independently would have to be calculated pursuant to some sort of a formula.
Why is that? It couldn't calculate it here mean simply set a number. I mean, I understand that calculated, we might normally think of a percentage of something. There's some sort of mathematical or arithmetic calculation, but couldn't the legislature simply be saying, when you set give a $10,000 bonus, or you say you're going to provide for a supplementary incentive, $1,000, that's all it means, that you're going to set a number?
Well, I look at the words of the statute and I look at those words and give them their plain meaning, as the appellate division spoke of with their exercise. Calculated, to my mind, as you indicated, means an arithmetic process. So in order to determine whether the amount of a supplementary incentive, a calculation and not a discretionary payment, not a just here is 10,000 or 100,000. It's subject to a calculation. Again, an imperfect statute, but that's what we're working with.
Counsel, were the payments promised here tied directly to the sale of PPE?
Yes.
why are they, and tell me why this may be an overly simplistic approach. Why then are they not simply commissions that the statute covers and not subject to any exclusion?
Because they are supplementary incentives, supplementing what was during this time frame, her day-to-day work.
But again, I think you're putting a lot of emphasis on the fact that this was the beginning of COVID, and it may have been a short-term sale product that the company was selling. As Mr. Atkins pointed out, if the demand continued for the next 4 years for PPE, that would have been the product that the company was selling for 4 years, 5 years, 20 years into the future, correct? So there was no indication at that point in March of 2020 that this was going to be potentially a short-term thing. So it sounds like your argument is, well, it's supplemental to the software that the company was selling, and that's where supplemental is coming in, that it's supplemental in terms of the product and the service that the company is providing. Is that what you're arguing the legislature intended for supplemental to mean? Because it sounds like that's what your argument is, that supplemental means if the commission is tied to a service or product that the company does not usually provide, that's what a supplemental incentive is. And I'm not sure that's right.
Well, I don't know that the legislature contemplated a pandemic that brought the world to a halt and the shortage of PPE, so I don't
think it matters.
Yeah, I can't.
Do you think that the word supplemental really only categorizes incentives that result from products or services that a company is selling in addition to their usual products or services?
Right.
So if a company has a commission schedule for the sale of fruit, if midstream they say we're going to expand and we're going to start selling vegetables now as well, fruit sales are commissions under what I just heard you say, but vegetable sales would be supplementary.
It's a difficult hypothetical to address because I don't think it's applicable to these facts at all.
That would take the examples that were provided of what is a supplemental incentive out of that category, because what those examples were dealing with is nothing about a new product. It's just
right.
That we've got a space need that we're asking you to do something that we know is inconvenient.
Right.
So we're going to give you, so that would knock out those examples.
Right. Yeah. I don't think when you're staying within the realm of what your business is and selling something akin to what you've been selling, as opposed to something radically different happening in a moment in time, I believe that is a very significant distinction.
There's no clue at all that was the distinction that legislature was trying to draw. And respectfully, the business is fluid and constantly changing, and some businesses, not all, but some businesses, especially distributors and people who are the middlemen in a sales relationship, might shift, not just from the chief's example from fruits to vegetables, but to a product that just come on the market and they can warehouse that and sell it, and their salespeople are getting commissions for that. There's no clue that the legislature saw that differently.
I agree. There's no indication that they did. But what the appellate division did here was to look at the facts and circumstances of this case and determined under these circumstances, these are supplementary incentives that do not qualify as wages.
But we would have to create a rule that wouldn't only apply to the facts of this case, because we would have to write an opinion that explains it. So how could we fit that within the statute? Would we be saying something like, if it's far enough away from what you had been selling, even if you say you're still going to give commission for it, then it's not a commission anymore. Now it's a supplemental incentive. Whereas if it's similar, fruits and vegetables are the same. But if you used to sell fruits and then you decide you want to move to selling couches, then it's no longer a commission. It's a supplemental incentive.
I think, Your Honor, that under these circumstances, and these are very discrete circumstances, more than one of my opponents acknowledged that this is a unique set of circumstances. The question for the court is simply whether or not under these circumstances, these payments qualified as supplementary incentives or not.
Well, COVID, one hopes, is a unique circumstance.
Right.
But a business's shift in product that is a response to an abruptly arising consumer demand is not.
Right.
Respectfully.
I would agree with that.
And so it happened in the context of COVID, and you know, we hope we'll never see it. It's like again, but this is the general idea that a business will shift gears because a new product is out or an opportunity is out there is as old as commerce and presumably will exist forever in the economy. So I just respectfully don't see any clue that's where the legislature was trying to draw the line.
But I do think that's what the appellate division had in mind when making the distinction in this case.
I agree with you.
Yeah.
Question for us is that the proper interpretation of the statute?
Yeah. And I'll come back to what I said earlier, how the appellate division, how Judge Sabatino concluded his opinion with the indication that if necessary, the legislature should revisit the language of this statute because, again, it is imperfect.
Counsel, I'd like to better understand the depth and breadth of your argument by returning to the Chief Justice's hypothetical. I'd like to ask it a slightly different way. Let's say in this case, all stays the same, except instead of selling PPE, they sold a software program intended to manage the sale of PPE by other manufacturers. The sale of that software program be a commission, or would the sale of that software program be a supplement? The money coming from the sale of that software program be a commission, or would the money coming from the sale of that software program be a supplementary incentive?
I think what you've just described is fundamental, integral to the business of Suuchi Inc. at the time, and that would be a wage because it would be a commission, but it would fall within the definition of a wage.
Even though it's, according to what your description before was, one time in responding to these extraordinary circumstances, it's still a wage because it's more akin to what the salespeople had normally done.
Yeah, I think that is correct, Your Honor, because it is what the business was designed to do at this stage, and that is to sell subscriptions.
But isn't that somewhat inconsistent with the company's own SCP, which actually on page 2 talks about a commission rate,
Right.
and it says a percentage rate applied to ARR or one-time revenue.
Right.
So isn't this one-time revenue already included in the company's own definition of commission?
The one-time revenue, the 1.75%, which is for a one-time sale, I think that's actually on page 3. It's 3H is the definition or the payment made. 3H actually for a one-time sale, but it's a one-time sale, not a recurring year by year subscription. It is a one-time sale of a subscription, which is different.
So there's a commission rate for one-time revenue.
Correct.
In the
Yes.
company's own plan.
Yes. Yes.
Other questions, anyone? Anything you'd like to add, counsel?
No, thank you.
Thank you. Thank you to all counsel. We'll take the matter under advisement.